So with that, we call the first case on the docket, case number 128162, TS and TS versus DCC Propane, LLC, and Dwight Baer. If I could have the parties are at the bench, so Mr. Howell, you may begin.
Thank you, Your Honor. I'll be very short. Good morning, Your Honors.
Good morning.
Distinguished panel. From the onset.
Did you want rebuttal? Did you want rebuttal at all?
No. I won't need rebuttal. I won't need much time for argument as well. I do owe the court an apology. I was retained to basically write the briefs in this case, and Mr. McKinney, who was trial counsel, was the one who was going to be arguing this, and I found out yesterday afternoon in an email that Mr. McKinney's decided that he wasn't going to argue this. Doesn't leave, I'm sure you're all experienced, so you understand how that works. You need a little bit of time to prepare to do things like argue these types of cases. I've been before the Court of Appeals and the Supreme Court many times, and I certainly have that experience, and I do write a lot. It's not a lot of time, and I do need to get at least 2 or 3 hours sleep, but I did jump right into the briefs when I found out yesterday. I reviewed the appellate's brief, appellee's brief, and our reply brief, and after doing so, I arrived at the conclusion that there was indeed really nothing more that I could add to what is in the briefs that hasn't been said, at least in our briefs. So I said, well, I guess I'll just show up and tell you all that the circumstances that I'm under, and apologize to the court. I understand the 14-day rule. I've been around for a while, so I didn't get an opportunity to file a motion to tell you that I'm waiving my argument. Because I don't have an argument, quite frankly. I'm resting on the briefs, and I do apologize for that.
Let me ask you something.
Sure.
You wrote the brief, okay?
Yes, I did.
I've been in your position where I've had to argue the day before. But when you looked at the brief and you picked it up, what issue jumped out at you that you're like, this is the one I want the court to pay attention to? Because that would help us.
I would say that probably overall, and that's because I've mediated over 200 cases as a mediator, and I've certainly been in lots of mediations and very complex cases. I do medical malpractice. That what we scribble down at the mediation, is it binding? Is it a valid contract? Does interest start to accrue on that? Is that what starts the ball to rolling, or is it just perfunctory? And I've always treated it with the respect it deserves, that we're here, we settled it, let's ink down what you want, even to the point where I send a letter out beforehand that says, if you've got anything special that you want in the contract or in the mediation agreement, that the final contract or anything that you want, please bring it with you, let me know, because we're going to make it part of the mediation agreement. And we've been doing that for quite some time. And I mean, there's cases where something very simple is inked down in 4 sentences at the end of the mediation, and everybody just works after that, and it works out fine, no formal agreements, nothing. A check's written and we're done. And there's those that go on for 30 and 40 pages.
But when are you saying interest starts to accrue?
Right. Sometimes we put in the mediation agreements that if it's not resolved within 30 days, there's not minors involved or not the fund involved, that interest will start to accrue. And then there's also the statute that sometimes people invoke, but it's rarely invoked. It's an issue here today. So that's what I mean by that.
And so do you argue then that the notes from the September preliminary agreement start the interest accruing?
That's our position, Your Honor. And that's the reason is because if you look back at the intent, when I can't remember the gentleman's name when he was talking to the committee and talking to the legislature who was involved that introduced the legislation to begin with, there were concerns about insurance companies dragging their feet and not paying timely once the case was resolved. That sort of wound up going into the statute, and that really was the intent behind the statute. And that's really the reason that I think that all of that is so important that it start right then.
Was there anything in that preliminary agreement indicating that an insurance company was on the hook for this payment?
I believe during discovery, the police report talked about who insured the truck And then there was a policy that was produced during discovery that showed the owner of the truck was who it was, and it was in fact covering employees who were drivers, and that it was the actually insurance company, and there was $5 million in coverage. And they were the ones that in the original releases that were sent over by the defendant were the named parties being released. So I think
But
based
that
on
wasn't
that.
in September though, right?
Pardon, no.
That was after September?
No, I believe, however, and I can't speak to it because I wasn't at the mediation, but there were insurance representatives there that were during the negotiation. I was told that by Mr. McKinney, but I don't know if any of them signed anything or did anything. I just know they were there during the negotiation process. So there was insurance carriers there. For who, I'm not sure. I assume it's for the defendants, period, because there was vicarious liability.
So, but the agreement in September could not become final, and it was until it was approved by court.
No, because that was not a condition that was reserved in the agreement, and there was no need for court approval of the settlement. It was a routine car wreck type case. Well, I shouldn't say routine.
Well, I thought there were minors involved, and so the court had to approve that part of the settlement that affected the minors.
Only if they didn't avail themselves to the new statute that was just passed, that 38-125, I believe, that if there was an apportionment of $25,000 or less and there were affidavits, there was no court involvement necessary whatsoever.
Okay, I understand that, but my understanding is from reviewing the record that that wasn't done till sometime in December.
Right, but it did not, that is correct. There was a misunderstanding, but the question then becomes, well, did the court really even need to be involved at all when there's an election by the plaintiff that this is what he's going to do, and he's going to execute the affidavit, set up the accounts, do all those things? Doesn't require the court's approval, doesn't require the defendant's approval, or anything of that sort. So once the other side's on notice that we're going to avail ourselves, that's something that was not reserved for anything past that in the mediation agreement. So if the mediation agreement is valid, it's a valid contract, and that's not reserved terms, then that's the end of it. That's a duty and an obligation that is imposed upon the plaintiff to make sure that there's a apportionment in compliance with the statute.
So your contention is that in the September preliminary agreement mediation, that the appropriate conduct occurred making the statute inapplicable for
Yes,
child approval?
Right, because there was contemplated the amount, which I believe was $750,000, and we're going to settle the children's claims. There would be dismissal of all claims against, the children and the parents had. So that would be the end of that. That would be the conclusion of it. So that's all then taken care of. The obligation and duty then is imposed on the plaintiff because he said that here's the amount of money, here it is. He's got to figure the apportionment. If he wants to avail himself on the court, get an ad litem appointed, go through the court approval process versus using 38-125, that's the plaintiff's decision.
But I agree with that. But how would the company know to pay what they're paying to the children until they've signed the affidavit that invokes that statute? That you see what I'm saying?
Absolutely, Your Honor. I totally follow what you're saying.
So I mean, it seems to me that it's hard to pick to say the date of interest occurred when the agreement was reached, when the plaintiff hadn't done all the necessary paperwork to allow payment.
Right, and that is what Judge Woolley said, and I believe that's the position that the defendants took. But the issue to me, or I should say for the appellant, is that once the settlement's approved, once the settlement is complete, there is a contract and the interest would start to accrue, or the 30-day abeyance period would start to accrue at that point in time. That doesn't require the defendant to know that what they're going to do with the money and how we're going to portion it out to the children. I mean, there's no requirement, there's no law, it's not in the statute that defendants participate in any way in that approval process, nor is there anything in the statute that says the court must ultimately approve.
So you're saying that the defendants should have just sent a check for the amount of the settlement to the plaintiff's attorney, and he held it in trust and to make the appropriate disbursements?
That's very, very well put. Yes, Your Honor, that's exactly what I'm saying. Is it, yeah, well,
And before the release language was agreed upon, et
Yeah.
cetera, the check should have been cut?
Reese, our position is that you didn't need to have a further release, because if you wanted to reserve any specific conditions, then you needed to do it there at the mediation and the contract. Now, that may be right, it may be wrong, that's why we have the Court of Appeals to make these sort of decisions and
Well, I
sort it
mean,
out.
I have participated in mediations where release language was brought, but there was none here. Is it your contention then that there was not intended to be a release in the?
No, there was never a contemplation or anything that was reserved in the mediation agreement, which is what I'm gonna refer to the original agreement as. There was nothing in there that said, we're gonna have another agreement, we're gonna add additional terms, or we're gonna clarify some terms, or anything like that. And I think I cited in the brief some of the case law that says that, you know, if you don't do that, that's not necessary if you have a valid contract to begin with. And the court can't go in and now add that and modify that, and that's the position that we've taken, Your Honor, in this case.
So, you said once the settlement was complete, what was the date of that?
Mediation was 9/22 of '23. And that's when the parties signed off on the handwritten agreement by the mediator, Bill Sanders.
And do you see any significance with the December date at all then?
I'm sorry, what?
Do you see any significance with the December date? Is there any significance?
I do, as an attorney, and not as an advocate, which I must be for the appellant.
Well, I appreciate your candor to the court.
I have to be honest, I mean, have you done these long enough? You asked my opinion personally versus my opinion as a zealous advocate for the appellant. You're probably gonna get two different answers on that. I have to be candid with the court on that. I think that if it wasn't crystal clear, at least, that you were gonna avail yourself on the statute, the 38-152, that perhaps there's a delay in getting that, having a complete understanding and a meeting of the minds. But as an advocate for the appellant, I have to say that I don't think so, because to complete Your Honor's inquiry about whether or not the court needs to approve things and the other side needs to know, that the whole purpose of approval of minor settlements going back in the early 1900s, I've written articles on this, was to basically protect the minor from any overreaching by the family.
Right.
And so the defendants, it was never to favor the defendants. I think I cited a case on that, an old case. But it was never the defendants in the case who were the ones who needed protecting. So if they didn't want to make sure that there was something in the agreement that said, we want some oversight on this, and we need to know what you're gonna do with this money, not just settle it and do a dismissal, then we need to reserve that in the agreement. And I think that's one of the reasons that I probably cited way too many cases for Your Honors to read on that particular subject, because I think it was a valid agreement, they didn't reserve anything. So they basically, by doing that, the plaintiff assumed the duty that they were going to either go to the court, get an ad litem, or they were gonna avail themselves on statutory exception, or whatever it may be, but they had no requirement to tell anything to the defendant or to the court. That's just something they had an obligation to do, and if they didn't fulfill that, by God, they're in trouble.
I'm intrigued by this idea that what was penciled down at the mediation agreement is the final agreement, because it appears that there is communication of an intent to draft up an agreement by both parties.
I guess I don't see that, Your Honor.
No? Okay.
So when are you saying interest is interest is to start in September? And when does it?
No, Your Honor, there's a 30-day advance.
Okay, so October.
Correct.
I'm sorry, I meant,
Right.
and then when are you saying it's terminated?
When it's terminated,
Right.
in this case,
Wouldn't that be when the actual checks were given?
I think when the checks are tendered without condition, yes.
And do you have a date?
I believe that was April 17th.
Of 24?
Yes, Your Honor.
All right, and one other question for refreshing my memory. What's the rate of interest?
18%, I believe, Your Honor. Pretty hefty. There was an attempt to deliver the checks on a couple of occasions, but there was conditions that were placed, and then a motion was filed. Ultimately, the court said, got sidetracked on that, but yeah. In my view.
All right.
No further questions?
Well, Mr. Howell, believe it or not, you have argued for 14 and a half minutes.
So I got one more minute.
You have, actually, you're down to 20 seconds.
Well, again, I do apologize. I didn't mean to argue, but I'm happy to answer questions because I did write the brief. So.
Well, you did write the brief, or you did write the briefs?
briefs,
Right.
yeah.
Yes, and we were looking at all the case law you cited. Never hold back on that. We appreciate that.
Okay.
All right.
Thank you very much.
Thank you. It's waiting to get to 15.
Yeah.
You may begin.
May it please the court. Your Honor.
Can I get your name?
Sure. Andrew Folston for the appellees.
Thank you.
Your Honors, there's a lot of basic principles of law that all clearly hold that this case should be decided in favor of appellees. The most obvious one is that a settlement or an agreement to settle a minor's claim is not binding under Kansas law merely by the agreement of the parent to settle. For at least 100 years prior to 2023, the only way a minor settlement could become binding was through court approval. That was because a minor could disavow that contract within a reasonable time after reaching majority. So the courts had always held that it was necessary for there to be court approval for it to be binding. In 2023, there was a new bill added, KSA 38-152, that said if certain procedures were followed, that would make it binding. So either there has to be court approval or those procedures have to be followed. And there is no argument to be made that there was court approval of this settlement at the mediation in September 22, 2023, or that those procedures were followed. For instance, the September 22nd, 2023 preliminary agreement does not say that the distribution to the minors is under $25,000, as is required by the statute. It does not have any of the affidavits that are clearly required by the statute.
So how do you take this argument that it should have said that if you intended to abide by the statute?
Well, Your Honor, I think at the time of the mediation, first of all, Your Honor, I believe that whether it's binding or not does not matter if the contract says that you have to then make it binding. I think that as a matter of law, the parties would have to follow the steps to make it binding, whether or not the actual underlying agreement says so. Moreover, I would say that at the time of the September 22nd, 2023 mediation, there was no communication or understanding that the plaintiff would proceed under KSA 38-152. In fact, defendants are the one that asked them if that's what they were wanting to do several days afterwards, and did not actually hear back on that for several more days. And then plaintiffs then switched their mind again to wanting court approval before switching back to wanting to follow the statute. So clearly, to make it, for a contract to be binding, it has to be binding under law. Whatever the contract says, I think that's a basic principle underlying.
So your contention is that even if they didn't intend to follow the statute, because the minors were a party to the settlement, the court would have had to approve even without the statutory?
Absolutely, Your Honor. There was two options. They had to follow the statute, which they certainly hadn't done as of September 22nd, 2023, or they had to get court approval, which they obviously never did.
So then, are you saying interest started on December the 10th when the court approved?
I don't believe the court ever approved the settlement on December 10th, Your Honors.
Well, there was a hearing with Judge Woolley, wasn't there?
There was one of many hearings that day, and I actually believe on that day the court was sick, and so that hearing that was then postponed. And what actually occurred that day was an attempt at mediating the agreement.
So what day did Judge, refresh my memory then, what day did Judge Woolley sign an order that this is final and it's subject to appeal?
The court did not enter the final orders until specifically on, oh, excuse me, it was May of 2024. It was specifically on May 1st, 2024, is when the court entered its final rulings on the case and decided all issues that were outstanding. In fact, there was never any approval. The plaintiffs ultimately did decide to follow the statute and executed affidavits and executed a final settlement agreement in April of 2024.
But affidavits were done before that.
I believe the new round of affidavits was submitted with that settlement agreement, with the new settlement agreement in April 17th, or excuse me, April 17th, or right around then, when the parties were able to resolve everything outstanding except the attorney fees and the statutory interest. So there was no court approval. They ultimately did follow the statute. And I would also point out that when we did actually get finally executed affidavits, we tried to offer payment. In fact, we tried twice in December to hand them to plaintiff's counsel in person and then to mail them to him. The only condition being that he simply leave it in trust to make sure that the district court would not decide that there had not been a valid settlement agreement, which was a fairly justified fears because in that hearing with the court mentioned several times reasons why it might find that there was not a valid settlement agreement, or that it would not approve the minor apportionment.
And when was that hearing?
That, Your Honor, I believe was January 17th of 2024. Because that's when because at the December date, the court was, I believe, was unable to make that hearing. So the parties attempted to negotiate, that failed, so then the court cured everything on January 17th.
So what created the need to do a second set of affidavits for the minors?
I believe my memory is that they were just generated as part of that agreement. They were included with the final settlement agreement that the parties ultimately signed, and just to have all that in one document, have all signatures signed at the same time, just to make things what we thought would be easier and cleaner. But certainly no earlier than, even if you ignore the later settlement agreement, certainly no later than December of 2023 did those affidavits get signed. And even then I would still argue that the preliminary settlement agreement did not meet the requirements of KSA 38-152.
And by preliminary, do you mean the September?
Yes.
Okay, go
Still
ahead.
did not meet the requirements because, again, that did not apportion it out to where the minors were receiving less than $25,000. It did not make any reference to how that settlement payments will be paid. And subsection E of that statute says that a signed settlement agreement entered into on behalf of the minor is binding if it's in compliance with subsection A. So I would argue that every portion of subsection A has to be complied with and as part of the settlement agreement for that for it to be binding under the statute.
So affidavits were submitted in December.
Yes, Your Honor.
The court had a hearing on that in January.
Yes, Your Honor.
Didn't make decision then, correct?
Correct, Your Honor.
Then in February, you requested to deposit the settlement funds.
Yes, Your Honor, because they had refused to accept payment.
So you believe there was an agreement then before February?
We believed that by February, there was a reasonable argument to be made. We didn't believe, we believed by December there may have been a reasonable argument to be made. And we didn't want it to be an inequitable situation where we were enjoying the use of the settlement funds and plaintiffs were not able to access it. And also by depositing into the court or by depositing into a plaintiff's trust account, it could then earn interest, which then the plaintiffs may be able to use. So we were just simply trying to, not necessarily would agree that there was a completed settlement, but that there may be an argument that there was at least, and that we wanted to try and make things fair and equitable for the plaintiffs.
Okay, and so that attempt was made in February, but with the condition being that it be put into a trust account until
the court ruled, because again, the concern was, and I think vindicated by Judge Woolley's comments during the hearing, that the court might find that there was no settlement agreement. or that he would not approve or allow the apportionment of the funds. And I believe that the law allows for some level of reasonableness, for some level of practicality on that, and to allow us to at least condition on when there's a pending ruling by the court that may find the entire settlement invalid, that the funds be held in trust, and that not constitute a violation of the statute, of the interest statute, KSA 40-2126. But even if all that were not true, even if the September 22nd mediation agreement were a final settlement, there was no other things needed, we still would not owe interest under 40-2126 because the plain language of the statute does not include propane companies and propane drivers. It does not include amounts due under settlement contracts, and it does not include when there is not an agreement between a claimant and an insurer.
Okay, I'm interested in this reading because the plain language of the statute applies when an insurer is required to pay to the insured.
I would agree that that is exactly what the plain language says.
And
Your Honor.
was there, I'm assuming there was an insurer that was required to pay to the insured in this case?
No, Your Honor, there was not. Because the insured was my clients. It was not plaintiffs. This was not a first-party insurance claim, which I believe is what this statute is actually aimed at, is when you sue your own insurance company and they don't pay.
Except it says claimants, it doesn't say insureds.
I believe the claimants could be, I don't believe that was intended to, I believe a claimant can be another word for an insured, but I don't believe that a insurance company, fraternal benefit society, and reciprocal or inter-insurance exchange is another word for propane company or propane truck driver.
No.
And it
In this case, the required payer would be the payment from the insurer to the insured, and the claimant would be the plaintiffs.
The payment, as the insured, we were not paid by the insurance company. They sent that money directly to the plaintiffs. Part of the settlement was funded by us due to the insurance arrangement.
So what you're saying is there was a separate amount of money sent directly from the insurance company to the plaintiffs?
Yes, Your Honor.
And was this litigated at the district court level? The who paid the plaintiffs what?
No, Your Honor. That was between our client and the our insurance company. So there was no disagreement about that. It was just simply how the contract and the relationship was structured. So we just simply followed that. The issue is that the plaintiffs are not. The issue is that the insurance company was not required to pay anything by the September 22nd, 2023 settlement. That the amounts due was not to plaintiff, were not due under a contract of insurance. The September 22nd, 2023 agreement is clearly not a contract of interest. And there was no agreement between a claimant and an insurer. There may have been a claimant, but there was no insurer in the September 22nd, 2023 agreement. Obviously, there was no insurance company that signed it.
But there is, in the ultimate settlement agreement, there is an insurance company.
And if plaintiff wanted to argue that that interest applied to that settlement agreement, perhaps they would have an argument. But that's not the insurance. That's not the settlement agreement that they're arguing under which insurance is due. They're arguing it's due under the preliminary settlement, which did not mention an insurance company, did not say that any amounts were due by an insurance company.
So insurance company would have no notice then, that it was required to make a payment?
That's certainly possible, Your Honor. I don't know if that happened in this case, but I believe the most important part is that the plain language of the statute says that it only applies when an insurance company or a type of insurance company fails or refuses to make payment due under a contract of insurance. Again, the payments that the plaintiffs are claiming was due under a preliminary settlement agreement, not a contract of interest, and it was not due from any of those types of insurance companies.
You said
But they were-
contract,
Go ahead.
you said contract of what? Give me the terms again.
Contract of insurance, it's the quoting from the statute, Your Honor.
So the payment that was made for the 700 and whatever under the actually executed agreement,
Yes, Your Honor.
your contention is none of that 700, but this was not litigated at the district court, none of that amount was an amount that resulted from an insurer owing it to the insured.
Yes, I would say it was due from the insured to a claimant. I wouldn't say it was due,
Because I don't know why there'd be an insurance company released then.
sure, it was due under a contract of insurance between my client and the insurance
The
company.
insured and the insurer.
But it wasn't due to plaintiffs who were not insured by, and under the settlement agreement, there was no money due. The settlement agreement under which they're claiming interest, there was no money due from an insurance company. It only became due, arguably, under a secondary agreement. Not-
I have one quick question, because you made a pretty broad statement that you think this statute is not applicable, to third-party claimants. And is there a case that you believe says that?
I believe just the
That's-
plain language of the statute says that.
Okay.
Based on the fact that it talks about when an insurance refuses to pay under a contract of insurance. Pay amount due under contract of insurance. The settlement agreement under which they're claiming is not a contract of insurance and no insurance company had any responsibilities under that contract.
All right, thank you. Thank you.
Thank you, Your Honor.
Appreciate your argument, sir. All right, as no rebuttal was requested, we will take this matter under advisement, and we will call the second case then. Gentlemen, we appreciate your arguments.